Good afternoon, everyone. I'm Tom Farr, president of the Religious Freedom Institute in Washington, D.C. Welcome to another in a series of our webcasts on the subject of religious freedom around the world. Today, we're going to be focusing on the United States and talking to one of the outstanding young authors and activists, scholars in our country today, Ryan Anderson, who's written a fascinating article in the current issue of National Affairs, and the article is entitled Proxy Wars Over Religious Liberty. Before I introduce Ryan, I'd like to say a word, if I could, about the Religious Freedom Institute for those of you who are not familiar with us. We promote and defend religious freedom for everyone, everywhere. We have action teams around the globe in South and Southeast Asia, a huge area of the world, in the Middle East, a very important area for religious freedom. We're active in Europe, we're active in sub-Saharan Africa. We have an action team on North America, which currently includes Canada and the United States. And we have action teams on Islam and religious freedom and on foreign policy or international religious freedom policy and religious freedom. And finally, and perhaps most importantly for our discussion today, we have a center on religious freedom education, which is designed to return to our educators the notion that religious freedom, and to our students, that religious freedom is an important part of American life. It is, as it was once styled, the first freedom. And our educators, of course, are those in our schools and our high schools and colleges in particular, but also much beyond that, our civil society leaders, our media, our religious leaders. So we defend religious freedom, as I say, for everyone, everywhere. And this is part of our educational effort today. I'm delighted to introduce our guest to you, Ryan Anderson. Ryan's a busy guy. Let me just tell you a couple of things that he does. He is the William Simon Senior Research Fellow at the Heritage Foundation. He's the founder and editor of Public Discourse, one of the best, indeed, arguably the best online journal on religion and public life out of the Witherspoon Institute at Princeton, New Jersey. He is the John Paul II Teaching Fellow in Social Thought at Dallas University. Ryan, I might tell you, I have a granddaughter who is matriculating in the fall at Dallas University. And he is also a professor, an adjunct professor at Christendom College nearby here in Front Royal, Virginia. His books, every one of which are relevant to our subject today, and I'll tick them off very quickly. Most recently, When Harry Became Sally, Responding to the Transgender Moment, Truth Overruled, The Future of Marriage and Religious Freedom, which is my personal favorite. He's co-author of What is Marriage? Man and Woman, A Defense, along with Robert George and Sharif Girgis. And finally, also relevant to our discussion today with Sharif Girgis and John Corvino, Debating Religious Liberty and Discrimination. Ryan's research has been cited by 2 U.S. Supreme Court justices in separate cases, by Justice Alito and Justice Thomas. He received his Bachelor of Arts from Princeton University, graduating Phi Beta Kappa and magna cum laude, and his doctorate in political philosophy from Notre Dame University. Ryan, welcome to the program. We're delighted to have you.
Great. Thank you. Happy to be with you.
Let me begin by just sketching very briefly the outlines of your. Before I do that, though, just a personal word, if I might, which conceivably could explain your disappearing from the screen, and that is that Ryan and his wife are within 48 hours due to have their second child, and we rejoice with you and your wife in this, Ryan. We hope that the baby will be on time, or in other words, will not appear within the next 45 minutes or so. But if he or she does, we'll know why your screen goes by. Welcome again.
I'm sure my wife would prefer that the baby show up in the next 45 minutes rather than days from now.
Right. That's why I said that little prayer. We'll hope that God is listening to me rather than her at the moment. All right. let's turn to your article again in National Affairs magazine, current issue. If you haven't read it, hope you'll want to read it after our discussion today. And if you haven't, we are unable to get it just by Googling it, which you probably can, let us know. We'll get it to you. It's entitled Proxy Wars on Religious Freedom, National Affairs Journal. Here's the basic theme of the article, and then I'll turn to you, Ryan, to talk a little bit about it. Ryan says that religious liberty is, or has become, a proxy war, or if you like, a proxy battleground. That is, I think he means a substitute ground of battle, which is accepted by both sides of the disputes on our culture war issues, the issues of marriage, homosexual marriage, same-sex marriage, some of the issues of life, all of the culture war issues that we're all familiar with. The reason, he says, that left and right are willing to fight this on the proxy ground of religious liberty, the substitute ground, is that it allows them to avoid grappling with the moral goods that are involved in these culture war issues. And the results of this agreement on a proxy war are two things that are not good for any of us on any side of this issue. I would argue at least one of them is not good, and that is confusion over the issues themselves. The culture war issues that are under debate get confused because they're not fought, in Ryan's view, on the proper ground. And we don't really grapple with them as issues of moral truth, moral good. But secondly, and here I'd like to get to this will be laced throughout our conversation, but maybe a little bit more toward the end of the conversation. He says it puts at risk our capacity to defend the true meaning and value of religious freedom. So as somebody who is heading an institute that is trying to defend the true meaning and value of religious freedom, we, of course, at RFI are very, very interested in what you have to say in this article. So let me turn to you, Ryan, and begin by, first of all, asking, did I characterize your views right? I presume you can do that as well or better than I can. At this level now, staying at a fairly general level at this point, and ask you this question to let us get a little bit into it. If I've characterized it right, do both sides, why do they accept religious liberty as a proxy or a substitute for engaging on the substantive good of marriage? Or maybe to put it a little bit sharply, why would both the left and the right, which is what I think is a shorthand for what we're talking about here, a little more complicated than that, but basically, why would they both accept this proxy ground to fight these important issues?
Yeah, great question. And yeah, I think that is an accurate summary of the essay. It's funny because as I was, thinking about and writing the essay, that wasn't the primary two kind of like sides that I was thinking of. I was thinking more of within the conservative family, there are some conservatives who seem not to want to talk about the substantive issues, so they pivot to religious liberty. And then that inspires a backlash of conservatives who are giving up on religious liberty because they think it's a poor substitute for the actual substantive issues. And so, especially publishing it in National Affairs, I was thinking, I'm speaking to my kind of fellow conservatives of, we want to avoid both of these two extremes of placing all of our eggs in the religious liberty basket, or kind of like throwing out the baby with the bathwater, right? A title of a previous National Affairs essay of mine. But the idea of giving up on religious liberty or denying that religious liberty is a real important human right because we think it's a poor battleground for discussing these other issues. So to answer your question, why do I think some people, especially on the right, prefer to kind of pivot to religious liberty is partly because it's safer ground. They think it's safer terrain. It's more solid terrain. It's less likely to get them called various names or be uninvited to the right cocktail parties, et cetera, et cetera. And I'm being a little flippant in the way that I describe that. But I also think there's a real nugget of truth to that. It's much more controversial to say, I don't think we ought to, and then fill in the blank, give puberty blocking drugs to children, allow high school males to compete as high school girls. It's much more, difficult to state those claims than it is to say, I think we should protect religious freedom for all. And so I think there is, some, what's the right way you put it? There's a temptation to run away from those underlying kind of questions that we do have deep disagreements to say, let's talk about the religious liberty thing, which hopefully we have agreement on, at least at the level of principle. But I think one of the risks that we run here is that we actually can undermine some of that consensus on religious liberty as a principle that we all can agree to if we start using it to fight proxy wars. And so anyway, I mean, that was part of the motivation behind the essay, and the title of the marriage book, Truth Overruled. It's the subtitle, The Future of Marriage and Religious Freedom, that was meant to communicate. I think we have to kind of, walk and chew gum at the same time. We have to engage on parallel tracks. We should be defending religious freedom, and we should be defending the truth about marriage. Right? We should be defending religious freedom, and we should be defending the truth about the human body as male and female when it comes to gender identity questions. We shouldn't give up on either of those important public tasks, nor should we conflate them and, use the religious liberty issue as a proxy for talking about either marriage or gender identity. And I think you see this particularly in the case of politicians. Lots of politicians feel much more comfortable talking about religious liberty than they do talking about anything related to gender identity, transgender identities. That's what I mean by it being safer, more secure ground. They're familiar with it. We've been talking about religious liberty for a while. For many people, the transgender set of questions, gender identity questions, are relatively new. And they either, haven't had the time, or they just aren't interested in doing the homework to kind of equip themselves for having that conversation.
Right. Well, certainly, with respect to the political parties, if you would expect to find most people who defend the traditional understanding of marriage, you would expect to find those in the Republican Party, or those who would want to defend the traditional understanding of man and woman biologically as well in the Republican Party. But you're quite right, they don't talk about this on those grounds, and they are willing to talk about it in the narrower terms of religious freedom. But is it just on that fact, on that proposition, do you think it's working for those on the right? I mean, that is to say, is it in fact safer now? Maybe it was 5 or 10 years ago, but we see the mainstream, so-called mainstream media putting religious freedom in scare quotes. We see as if it were something to be scared about. We see the old and venerable Civil Rights Commission created in the 1960s to protect the civil rights of all Americans and all American groups, opining in a few years ago at the end of the Obama administration, the chairman, you may remember this, Ryan, the chairman.
Chairman Castro, yeah.
Yeah, he said religious liberty, I mean, I can almost quote him, but basically it's fair to say, he said, religious freedom is a front for bigots and haters and racists and misogynists. That's not exact. If people believe that of those who are defending or fighting on the ground of religious freedom, it's not quite as respectable a ground as they may have thought. I mean, do you agree with that, or is it still a safer place for politicians who don't want to get into this on the substance?
I mean, I think rhetorically it's probably a safer space, but I think it's an ineffective long-term strategy. And so it might both be safer, but doomed to fail, and ineffective if you're playing to win the long game. And the reason why I think it's ineffective is just think about how we've treated religious liberty protections and religious liberty claims for two different groups who have lost major Supreme Court cases, racists and pro-lifers, right? And so we've had big Supreme Court cases on both of those issues. Racists lost those cases, pro-lifers lost those cases. And when it comes to religious liberty, we don't carve out religious liberty space for racists. We do carve out religious liberty space for pro-lifers. And I think the reason why is that on the underlying substantive issues, racism is indefensible, whereas pro-life commitments are true. And we've been defending them as true, not just as, our distinctive beliefs. And so the pro-life community did two things simultaneously. They pushed for conscience protections and religious liberty protections to prevent pro-life doctors and nurses from having to perform abortions, taxpayers having to pay for abortions. So things like the Church Amendment, the Weldon Amendment, the Hyde Amendment are important. But they didn't settle for that, right? They also made the argument that abortion is unjust for anyone to engage in, that the unborn baby has a right to life that all of us are obliged to respect and to protect. And I think that the first set of arguments went better. They were more successful. They were more effective in the long run, precisely because of the second set of arguments that were more likely to protect the conscience rights, the religious liberty rights of people exercising those rights in ways that we think are reasonable. In fact, this is even kind of like it's baked right into both U.S. Case law and constitutional law and statutory law on these questions. And it's baked into, to my mind, the best philosophical and theological defenses of religious liberty. That religious liberty isn't an absolute right. Religious liberty has limits. It's limited by the demands of justice, the demands of public order, the common good. The RFRA standard says compelling government interest, least restrictive way possible. And so right in both the legal and the philosophical and theological defenses of religious liberty, it has certain limiting principles. And so one of those limiting principles is that you can't be kind of like grossly undermining the public order, the common good, the demands of justice, and then claim a religious liberty defense. So we don't protect religious liberty for Aztecs engaged in human sacrifice. We don't protect religious liberty for racists who are engaged in invidious forms of discrimination. And so the underlying question here becomes, is the pro-lifer engaged in something akin to invidious discrimination? Is Jack Phillips the baker engaged in something like invidious discrimination? And so to properly answer that, we're going to have to both defend the religious liberty claims, but also defend Jack Phillips's beliefs about marriage as not just idiosyncratic beliefs, but as something true, good, beautiful, et cetera, et cetera.
Okay, I'm glad you raised the pro-life issue because it really provides a good way to talk about this. But I want to come back to it, and let me just lay down a predicate on that now, and ask you one other. Go back before we leave the question of left and right. I don't want to let you off the hook about the left and why they are comfortable in the proxy war. But before we get there, while it is true that the pro-life in both ways has argued that this is true and that it's a matter of justice to protect the conscience of those who believe it true, they have also protected the right to change the laws. They have never given up on the proposition not only that Roe v. Wade should be overturned, which of course is an aspect of political life that involves who we vote for president, but that the laws in the states to which Roe would return it if it were overturned should defend life. And so they're prepared not simply to protect the consciences of those who are not accepted or who are not protected by the laws that permit abortion, or not. They want to protect the consciences of those who do not want to participate in abortion, such as doctors and nurses. But they want to change the laws in the first place so that we're not just talking about carve-outs for those whose consciences are abused. So I do want to come back to that because I think that's a major aspect of your article. And it really does get to the limits on religious freedom that you were referring to. And perhaps I wouldn't call it a disagreement between us, but something that we need to fine tune a little bit about what those limits mean.
Yep.
But let me, if I, and also Jack Phillips, we want to come back to him as well, because he's a very good example of what we're talking about here. Before we do that, though, could you just very briefly, if you like, say, is it the case that you think people on the left want to fight a proxy war because they are uncomfortable defending the ground of moral truth that they almost certainly would say that they're standing on?
Yeah, so that's where, within your summary of the essay, I don't know if they're fighting a proxy war so much as they are using the religious liberty issue precisely to solidify what they see as their wins on the abortion issue, on the marriage issue, and they hope on the gender identity issue.
Okay.
And so I think that's where I would say it's more for the left of saying, look, just like we can't tolerate religious liberty for the racists, we can't tolerate religious liberty for Jack Phillips. We can't tolerate religious liberty for Catholic charity adoption agencies. We can't tolerate religious liberty in these other circumstances. And they're relitigating what had been a 40-year kind of settlement on some of those conscience protections for pro-lifers. Right? And so what was interesting is that the HHS contraception and abortion kind of inducing pill mandate relitigated and unsettled whether or not we are going to protect people who have conscientious objections to abortion. And then you saw at the very end of that presidential administration, so in 2016, as they're getting ready for the new election, during the DNC, during the convention for the Democratic National Convention, they revoke their support for the Hyde Amendment. Right? And that was new, is that you saw that what had been, Joe Biden used to support the Hyde Amendment. Now he no longer does. Then he supported it again. I'm unclear where he's landed on this. Right. But it actually had the consequence of what had been kind of some settlement on these issues was actually now being relitigated.
And in fact, here I think I'm agreeing with you. They believe that on the grounds of religious liberty, they are winning in the courts, even though there have been some notable defeats in Hobby Lobby, for example, for the left. Whether that is a permanent defeat is unclear. And I would argue that precisely because of what you're talking about, the way the Democratic National Committee has adopted abortion as a good, not as something that as late as the 90s, President Clinton said should be safe and rare, presumably on the presumption that it is not a good, but a necessity or a right that must be given to a woman or whatever grounds it is. We seem to have bypassed that to the notion that it is a good, and indeed the doctors and the nurses that refuse to perform it in some cases, or to refuse to participate, certainly the nurses must do so, which is a very, very different point of view than what we've had before. So perhaps we could turn to this question of the courts in the way that lawyers is a fascinating section of your article that says conservatives who have criticized the defenders, the good guys, if you like, from our point of view, in these court decisions, conservatives who have criticized them for not arguing on the moral ground or other good grounds that you and I both would approve of in principle, are doing the right thing because they won't win. And you make the, I thought, striking claim that even in a court full of Antonin Scalias, in the I think it was was it the HHS mandate you were leading in, but you may have been talking about Hobby Lobby. What do you mean by that? Why would Scalias or take your pick of conservative justices not allow this moral good argument that you're calling for?
Yeah, so I mean, what I was arguing there is that we need to kind of see what the division of labor and what the kind of like proper set of arguments that our respective division of labor and our respective kind of vocational commitments kind of are appropriate to us. I was seeing, my friends of mine at the Beckett Fund for Religious Liberty, friends of mine at Alliance Defending Freedom, coming in for criticisms because they were making legal arguments that were winning, that weren't, philosophically engaging on those underlying moral disagreements. And my
so give an example. What's a winning argument? Hobby Lobby, or
so whether it would be Hobby Lobby, Little Sisters of the Poor, Jack Phillips. The criticism here was that why aren't they arguing that what the Little Sisters believe is true? Why aren't they arguing that what Jack Phillips believes is true? And the response is that, look, so long as Anthony Kennedy was still on the Supreme Court, you're not going to get his vote if the hinge issue here is whether or not what Jack Phillips believes is true. What the lawyers were trying to do is they were counting to 5, and they were saying, given the composition of the justices as they are, what's going to be an argument that gets us a majority of them to agree with, our client and our set of facts for this case. Now, the parallel criticism, though, was that just because the lawyers were making narrowly crafted arguments given the statute that they were litigating under, whether it was a RFRA case in the case of Hobby Lobby and Little Sisters, or if it was a First Amendment case in the case of Jack Phillips, that wasn't a reason for the rest of us to only speak as if we are lawyers. And so there was a temptation here of the rest of us to kind of limit what we were willing to say in the public square to only talking about compelling state interest, least restrictive way possible, underlying religious liberty, free speech arguments. To my mind, the bishops and other religious leaders should have been outspokenly defending the truth about what he believes about marriage in the case of Jack Phillips, using the Hobby Lobby case, especially the Little Sisters case, as an occasion to teach the truth about the Catholic understanding of human sexuality. But I don't think the lawyers should have been making those arguments, because I don't think that would have actually been very effective at getting to 5 votes in the Hobby Lobby case.
Could they win more votes on those issues now that Kennedy has left? Or do you think that the same problem remains?
Yeah, so this is where the part of your question that asked about, even in a Supreme Court full of Antonin Scalias, you wouldn't get this. And you see some of this being discussed right now with some of the criticisms of originalism. Adrian Vermeule, professor at Harvard Law School, wrote a provocative essay at the Atlantic's website a couple weeks ago now, arguing for common good constitutionalism against originalism. And the argument there is that we shouldn't just be tied to the original public meaning of the given text. We should be interpreting the text in light of other underlying moral principles. And then particularly in the case of where those underlying moral principles informed the very drafting of the text. And so that's a kind of a halfway house between the more extreme version of this, which would be kind of like a conservative Ronald Dworkian understanding, and then the version of this argument that says, look, the founders themselves, when drafting constitutional texts, were informed by certain natural law understandings, and so the words they used had certain meanings that should be informed by philosophy. The point I'm making is that there's nothing in the Constitution or statute that just says something like true moral beliefs have protection under our system of law.
Right.
And that's where, even if what Jack Phillips believes or what the Little Sisters of the Poor believes is true, and obviously I think it is, you have to then tether that to a specific constitutional provision or statutory provision that would offer them protection. And then the operating words in those provisions isn't whether or not it's true or false, but to take the RFRA standard, it's whether or not it's a sincere religious belief. Now, just because it's a sincere religious belief doesn't mean it's true, doesn't mean it's good, but that's the technical legal language that Congress wrote into the law for defending religious liberty. On the one hand, sincere religious belief, and is it substantially burdened? And then on the other hand, is there a compelling state interest, and is it being pursued in the least restrictive way possible? And that's how Scalia's, a whole court full of Scalia's, that's how they're going to rule on these cases. And so that's how the litigators are going to argue the cases. But that doesn't mean you or me or anyone else shouldn't be defending the broader issues that are raised by these cases, whether it be about contraception, abortion, marriage, gender identity, et cetera, et cetera.
Indeed. And I think, this is a major thrust of your article, that because of the reasons you cited and perhaps others, it's going to be very difficult to win these substantive issues in the courts, the federal courts, that politics, broadly construed, is the way people are going to have to do this. And I want to turn to that. But before I do, is it not the case that whether the courts are supposed to do this or not, they have in effect created you said there was no moral clause in the Constitution, you're quite right, but has not the court created rights such as in Roe and in Obergefell, rights to abortion and marriage, that de facto are teaching perhaps some of the people listening to or watching us on this podcast or on this webcast to believe that these are fundamental human rights and therefore, sort of by definition, social goods. The courts, in other words, have not stayed away from creating moral goods or opining about what is a moral good in recent years. Would you agree with that?
Oh, of course. I mean, that's exactly what a group like the Federalist Society or a justice like Scalia was trying to combat, right?
Right.
The argument here that what the court's doing is usurping legislative authority from Congress and acting as a supra legislature. Right? This is what Father Newhouse got in trouble for, what was it, 20 or 30 years ago now, when First Things ran the End of Democracy symposium.
Yeah. Right? The judicial usurpation of politics.
Yep, exactly.
Yeah.
That subtitle is so important, that politics has been usurped by the courts.
And even though I'm not a fan of Justice Scalia's Smith decision, this was the principal basis of his argument in Smith. Well, for those whose eyes are glazing over because of references to RFRA and Smith decisions and aren't familiar with them, let's turn to the perhaps more familiar term to what regular Americans can be doing, ought to be doing, if they feel strongly about these issues. You and I agree on the moral right of marriage as traditionally understand, and we defend particular points of view. I want to talk a little bit about the right of religious freedom as a way of not necessarily winning in the courts, and I think you agree with this, and in fact you say it in several places, but that this is a ground that isn't necessarily a proxy war. It is in fact a ground of political life as citizens, as free and equal citizens of this country, in which we can exercise, and that's a word, by the way, that is in the Constitution. It happens to be in the First Amendment to the Constitution, where it says something like, we have the right to the free exercise of religion, interpreting what that phrase free exercise means. So let's talk a little bit and go back a little bit to the pro-life groups and how it is that we can achieve collectively more scrutiny on the substantive issues at stake here. What is a man and a woman? What is a human being? What is human nature? What is marriage? Without getting too far afield on this is a big subject. I hesitate to mention it, but you do criticize, I think, correctly, conservatives who have decided to make a compromise in politics and in law. It's called fairness for all. And they believe that if they get some carve-outs to allow them to practice religion at certain levels, that they are willing to accept laws that put into our civil rights legislation sexual orientation and gender identity as two categories protected in federal law as civil rights, so that if you are sued successfully for abridging one of these rights, like sex or race or religion, three of the traditional rights, you can be sued and the fines can be ruinous. The consequences for you can be very harsh. This is very likely to be one of the first laws passed under a Democrat administration. All the Democrat candidates have said it. I believe Vice President Biden has said it, the so-called Equality Act. Yep. there are some conservatives who think, well, as long as there are exemptions for us that allow us to exist, to worship, to do our thing kind of privately, to run our organizations, you don't think that's a safe haven. Why not? Briefly.
Sure. Great question. I think you're exactly right. The people behind the Fairness for All Act are good people. They're acting in good faith. They've made a prudential judgment that the best way to protect religious liberty in the long term is to elevate sexual orientation and gender identity to a protected class while simultaneously passing certain religious liberty exemptions and protections that would limit the damage done by those sexual orientation and gender identity laws. And to do it now, because as soon as there's a lineup between both houses of Congress and the White House, with Democrats controlling the two chambers of Congress and the White House, they're going to pass the Equality Act, which is SOGI laws with no religious liberty protections. And so rather than, waiting for that to one day happen, we should pass this first. And it's not a crazy argument, right? It's obviously, there's a logic to it. The people promoting it are doing so in good faith. The reason why I think it's misguided is that religious liberty is not the only value at stake by SOGI laws. And so the pairing of, one side gets a new public norm that sexual orientation and gender identity are protected classes in federal law, and then the other side just addresses the religious liberty concerns that new public norm would create, rather than addressing all of the other concerns. I think if we want to strike a compromise, we should work for a good compromise. I'm not against compromise. I just think this is a bad compromise. And so let me just give you a couple specifics just so that our viewers can know what Fairness for All would do here. It says that every child in the foster care system would have to be treated in accordance with their self-asserted gender identity. So they have to be affirmed in their gender identity, and that no child in the foster care system can be given any therapy to help them identify with their bodies. So if I'm a 10-year-old boy from a home where there's been domestic violence, there's been lots of problems, which is why I'm now in foster care, and I'm identifying as a girl, you have to treat me as a girl. I now have a civil right to being treated as a girl. And if you try to do any intervention to help me identify as a boy again, you're violating my civil rights. Now, I don't see that as a religious liberty concern, which is why they didn't negotiate a particular protection here, because this is about an underlying substantive issue. What's in the best interest of these children? Is it in the best interest for these children to be giving puberty-blocking drugs, cross-sex hormones, to be affirmed in a mistaken gender identity, and to be prevented from being given good care, right? So Dr. McHugh wouldn't be, Paul McHugh, the former chair of psychiatry at Johns Hopkins, he wouldn't be able to treat these children the way that he believes they deserve to be treated under Fairness for All, because they now have a civil right against any sort of therapy that would help them identify with their body and to be treated in accordance with the new gender identity. To my mind, that's not something we should be giving up on to protect religious liberty. Likewise, what this bill would require is that every public school and every non-religious private school would have to do bathrooms, locker rooms, and sports in accordance with gender identity rather than biology. But religious schools could have, that carve out. Again, to my mind, it's not fair for all to tell secular women, secular girls, religious women and girls who are at public schools that their privacy, their safety, their equality on the athletic field needs to be discarded for the sake of securing religious liberty protections. So what I've proposed as an alternative is that rather than crafting the compromise as SOGI is elevated to a protected class and then there's certain religious liberty protections, why don't we actually define what is discriminatory that we are actually preventing? So that if you think about what we did with sex discrimination, we said no discrimination on the basis of sex, but single-sex bathrooms and locker rooms and sports teams aren't instances of discrimination. No discrimination on the basis of sex, but pro-life medicine isn't sex discrimination. You could see the argument. Only women get pregnant. If you don't perform an abortion, you're discriminating against women. Supreme Court has rejected those types of arguments. So we could say something like, you can't discriminate against LGBT Americans, but believing that marriage is the union of husband and wife isn't discriminatory for anyone. Believing that children deserve both a mother and a father isn't discriminatory for anyone. Believing that children should not be placed on puberty-blocking drugs or cross-sex hormones isn't discriminatory for anyone, and therefore anyone is free to engage in all of those actions, right? So there's a bright line limiting principle of what is discriminatory and what isn't discriminatory, rather than using religious liberty as like the proxy for figuring out, what those lines are going to look like.
Ryan, let me just respond to that by saying I think that is an extreme. I've heard you say it before. I think it is a very, very good critique of fairness for all and an accurate prescription of the way that we should look at this legally. But I would say that by and large, while I agree, these are not per se religious issues. They're issues of reality and biology, just as abortion is. The reality also is that there are many religious people who believe a man is a man and a woman is a woman, and that marriage is between the two of them for religious reasons. So speaking as a Catholic Christian, I would use the words of Jesus to buttress what I believe is true in natural law. And indeed, if I did not believe that this were a religious commandment, if you will, that makes sense in the natural law, that is to say, if the natural law is true, there ought to, there ought to be some evidence. There is evidence. There is revealed parts of this. So being religiously motivated, most of the people who want to defend what you've said tend to be religious people. And therefore, when they want to defend marriage on religious grounds, that is an expression of religious liberty. And it is one that I think the founders intended to protect. Now, your riposte might be that, yes, you would agree with that, but that fewer and fewer people who have the levers of power do not agree with that. And it's less of a winning strategy, which I suppose could be a reason for supporting the fairness for all approach. But then let me just make one final point on this, because we're coming up against our end, and I didn't want to end on fairness for all. But I'll give you the last word on that. And then I just want to do one other thing before we end. The premise of equality, the Equality Act, and indeed all of the SOGI laws, it seems to me, is that those who oppose sexual orientation norms and gender identity norms are like racists. This is why we have to put them into our civil rights laws, because those who oppose them are opposing something that is natural and good. And so we will carve out, for fairness for all or for other schemes, exemptions for them. And those of us on the other side who applaud the exemption, I think, are being naive because of what you said earlier. At the end of the day, we don't protect racists. We have a national consensus. Even though racism still exists, there still are racists in this country. We do not protect them by dint of the law. We generally don't make arguments in favor of racists. If people who believe what we believe for religious reasons about marriage and about life are akin to racists, why should we be given exemptions, or at least permanently? I think there is a terrible logic in fairness for all and accepting this that really is going to cook us very, very slowly, like the frog in the pot, but in the end, the same ending.
Yeah.
If you could respond briefly to that, I'd appreciate it.
Yeah, and just, I mean, one thing to think about this is an argument that I've made in writing with respect to the foster care children. If they have a civil right to being affirmed in their gender identity, why don't other children? Why don't, the child that is about to be born any day now, why doesn't that child have a civil right to being affirmed in his or her or their, or, it could be gender non-binary, gender spectrum. And that's the logic here. You identified it as if we come to be viewed as our beliefs about marriage are bigoted, but we just have these exemptions, won't over time these just be looked at as exemptions for bigotry? Here, if you create a new norm saying as a matter of civil rights, foster children deserve to be affirmed in their gender identity, that same kind of pedagogical function of law is at play of, well, why limit it to foster children? Shouldn't every child have this right? And again, that's where I think the better approach here is really defining what is and what isn't discriminatory. The other thing I wanted to add to your first comment about, just as a matter of empirical reality, the vast majority of people who agree with us about marriage as the union of husband and wife are religious believers, right? Orthodox Jews, Catholics, evangelicals, Latter-day Saints, Muslims, people within the Abrahamic faith traditions. And I think that's probably true as an empirical reality today about marriage. But I don't think that's true at all when it comes to gender identity. One of the things that I've been very kind of gratified by are the number of non-religious, non-conservative, particularly women, who have reached out to me to thank me for things that I have written, things that I have said, non-religious, non-conservative parents of high school and college age children who are transitioning against their wishes, wishing that they had people on their side of the political aisle or their side of the religious secular divide articulating the same truths. Right? And so one of the benefits of the way that I typically argue about marriage and gender identity is from natural law, philosophy, social science perspectives, is that it's accessible to non-believers. And I try not to be particularly partisan. So it's accessible whether you're liberal or conservative. And I've seen that be the case here in the gender identity issue. I don't think you need to be a conservative Christian to think that puberty blocking drugs are a bad idea. I don't think you need to be a conservative Christian to think the female athletes in Connecticut who keep losing championship races to biological boys are being treated unfairly. And so here's where I think that there's an opportunity to build some bridges. One of my favorite groups is called Hands Across the Aisle. And it's a bunch of conservative and liberal women reaching across the aisle saying we disagree about lots of things, but we agree that biology isn't bigotry. And that's what they're doing here. So I think before we preemptively surrender on, for example, the gender identity issue, we should form coalitions to defend the truth about sex and gender identity, and not just retreat to the religious liberty exemption. Because as you point out, the long-term consequences here, it's probably not going to be an effective long-term strategy, even if it's a more comfortable ground to stand on today.
Right. Well, I love your optimism, and I am temperamentally in sync with your idea of finding allies on all of these issues. I am reminded, however, that it wasn't long ago that most of us agreed on what marriage was. It was only 2008 that the state of California, not the most conservative state in the country, voted to make marriage in the California state constitution as defined as between one man and one woman. And the same people who voted for that voted for Barack Obama as president, most of them, many of them. Today, that has dissipated as a good. And I think one of the questions we need to try to answer is why that is. And I applaud what you're doing in order to reach across the aisle, so to speak, or reach to those who aren't religious. Certainly, the argument that we make at the Religious Institute is not against those who are not religious. Indeed, we define religious freedom as the right not to believe. But if you believe, you have certain things that follow. And I'd like to kind of end on this subject and see where I think our agreements are, and just defining religious liberty. Our position is that the reason the right to free exercise of religion is in our First Amendment. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. One of the things we know from from history is that they had considered another phrase for what became free exercise. It was the rights of conscience. So it would have been Congress shall make no law respecting the rights of conscience. And since there weren't any Catholics really involved in this drafting, these were mainly people formed by Protestantism, and the rights of conscience was absolutely natural, as it is today, to the way they talk about religious freedom. And yet, they didn't adopt that. They adopted this much more active noun, if I can put it that way. We have the right, or Congress may not prohibit, the free exercise of religion. What do they mean by that? I think there's plenty of evidence to suggest that despite their disagreements among themselves, they wanted religious people involved in our public life to bring to bear their religious and religiously informed arguments. Of course, they knew about natural law arguments as well, into our public life. Why did they want that? They wanted a virtuous citizenry, and they associated virtue with these religion-related arguments. They believed we would fail. Washington said in his second farewell address, we won't have political prosperity without religion and morality. Political prosperity. So there it is. If you believe that the free exercise of religion is not only a right, but as Madison said, the duty of everyone to bring to bear, not just in your church or your synagogue or your mosque or in your private relationship with the Creator, if any, it is also your right and responsibility to bring it into the public life of our country. Otherwise, they believed we're going to fail. That's why they came to recognize this as the first freedom. So I was really struck as I read the last part of your piece where you talk about politics. You talked about Robert Wilkins' wonderful book, Liberty and the Things of God, the Christian Origins of Religious Liberty. And you made the point that Robert was talking about, and the Christians of the first 1,000 years were talking about the interior disposition of the conscience. And then you went on to say, nobody cares what Jack Phillips, the baker's interior disposition is. He can believe what he wants. It's when he brings this into his public life, and I would add to that into our political life, even though that's not what Jack Phillips is trying to do, that we really get into trouble, which is why I want to sort of, I won't say end this, but get your response to the proposition that, and here I'll quote your very last sentence, 2 sentences of your essay, which goes back to everything we've been talking about. Religious liberty is a prerequisite for a moral life, but not the substance of it. A proxy war is not a substitute for the hard work of moral argument and moral formation. Would you agree with me that doing the hard work of moral argument and moral formation is in fact precisely the exercise of religious freedom that our founders wanted us to do as religious people? And therefore, the political work that you call for in your excellent piece involves the political work of religious people making their arguments in public life as well.
Yes, that's exactly it. That we don't argue for religious liberty for the sake of religious liberty. We argue for religious liberty for the sake of religious truth, for the sake of the religious goods and other goods that religious liberty is at the service of, right? And so kind of foundationally, we argue to defend religious liberty for the sake of the good of harmony between the creator and the creation, right? Between creature and creator. And so we protect religious liberty for all so that they have that space. In Madison's language, what's a rights amongst men is a duty towards the creator. It's the duty to render to God what we owe to God. That's not the only benefit. As you point out, it's not just to have that harmony between God and creatures, but it's also then to be able to do the moral argument and moral formation for other spheres of life, right? That part of what religions do, what religious traditions do, is that they form us. They inform us with certain beliefs, convictions, moral truths, but they also form our actions, our feelings, our emotions, our moral sensibilities so that then we live out certain lives. And so part of the critique here is that religious liberty is the prerequisite for then religious communities, religious institutions, and other institutions to do the hard work of moral formation, the hard work of intellectual formation. To my mind, the most crucial work right now is how do we form the next generation in a culture that is so hostile to both theological and philosophical truths, moral realism, metaphysical realism. When Hollywood, the university system, the public school system, et cetera, is shaping children in a very different direction, how do we do what we can to have countervailing institutions doing the work of moral and intellectual formation in accordance with reality?
Quite right. Well, I'll just end by saying at the Religious Freedom Institute, we don't defend those particular moral beliefs as such. We defend the right of people, and with Madison, believe it is the duty of people, really on both sides of this issue, to argue in public life and be able, as Peter said in 1 Peter, be able to give the reasons for the faith that is within you. Be able to explain to other people what you believe. And I would just suggest, Ryan, that while, as we've discussed, it is properly a mechanism, it is properly the vehicle by which we deliver those. But of course, in Dignitatis Humanae, the Declaration on Religious Freedom of the Roman Catholic Church, it declares as a Catholic doctrine that this is a good because it goes to the dignity of the human person. It reflects the right and the duty of the human person who believes in a truth, not only to believe it, but to make it manifest. And it is the right, and if I might, I'll just end with this. It is the right and the duty of governments to show religion favor for this particular reason. It is a good because it protects the dignity of the human person. And I think that is probably the best reason that I know of to protect religious freedom. Thank you, Ryan, for being here. All of you, I highly recommend, I think you probably want to read it now if you haven't already, Ryan's terrific piece. Read his books too. He's one of the best people out there writing on all of these subjects. Thank you for being with us.
Thank you.